Hello everyone, welcome back to NCA Exam Pathway. So today's discussion is particularly for the NCA candidates who are planning to prepare Canadian Administrative Law. This discussion aims to guide you to approach the Canadian Administrative Law syllabus like a pro. So before moving to the syllabus, you must know what is administrative law. So according to your syllabus, administrative law is the body of law regulating the ways in which government operates. So it is all about rules and limits that apply not only to the operations of the crown, cabinets, ministers, and government departments or municipal corporations, but also to the various administrative tribunals and agencies that governments use for carrying out the governmental functions. So it is concerned with the procedure by which all of these instruments of government operate and the substantive scope of their mandates, also the remedial structures that exist to ensure that decision makers act in accordance with rule of law. Now, next, you must understand how the subject is structured. So, this you can understand from chapter number 1, that is setting the stage. So, when you will read this chapter number 1, you will see that the syllabus divides administrative law into three parts. The very first area is procedural fairness. So basically, this area focuses the procedural side of administrative decision making. In other words, you can say that the circumstances in which government decision makers owe a duty of procedural fairness to persons affected by their decisions, and where such a duty exists, what that duty requires. The next area is substantive constraints. So this area moves from the procedure used to make the decision to substantive limits on the administrative decision making. Basically, it focuses on the extent to which courts can review the substance or the merits of the decisions made by the administrative decision makers and the standard of review the courts apply when doing so. Now, the next and the last area is about judicial review, that is challenging the administrative decisions plus the remedies on judicial review or what relief is available to a person. Okay, so this area stresses on the remedial framework, basically governing how the superior courts at both federal and provincial levels exercise their powers of judicial review. And if judicial review is available, what is the appropriate approach to the review? And then what remedy, if any, should be followed? Now, next, we will begin with the first broad area, that is procedural fairness or procedural expectations. Stay connected. Thank you.